After this stalemate was lifted by a letter dated 17 December 1986, two things happened, namely a change in the diameter of the pipes supplied by the respondents for carrying out the contract and request for the performance of additional work without finalization of the modified rates. Full stop. Therefore, the respondents cannot even accuse the appellant of non-performance of the contract. Full stop. It is fundamental to the law of contract that whenever a material alteration takes place in the terms of the original contract on account of any act of omission or commission on the part of one of the parties to the contract, it is open to the other party not to perform the original contract. Full stop. This will not amount to abandonment. Full stop. Moreover, abandonment is normally understood in the context of a right and not in the context of a liability or obligation. Full stop. A party to a contract may abandon his rights under the contract, leading to a plea of waiver by the other party, but there is no question of abandoning an obligation. Full stop. In this case, the appellant refused to perform his obligations under the work order for reasons stated by him. Full stop. This refusal to perform the obligations can perhaps be termed as breach of contract and not abandonment. Full stop. It is interesting to note that the respondents did not choose to allege breach of contract against the appellant and consequently to invoke the right to rescind the contract under clause 3A. Full stop. The respondents, if they were justified in doing so, could have taken recourse to the remedy available under Section 75 of the Contract Act and sought compensation for the damage sustained through the non-fulfillment of the contract. Full stop. On the contrary, they attributed abandonment to the appellant without understanding the true purport of the word abandonment and refused to honor the claims made by the appellant. Full stop. The finding of the High Court that there was abandonment of contract was on the basis that after the second bill was cleared in May 1987, the work under the main contract did not progress. Full stop. This finding goes completely contrary to yet another finding that the period of the contract was up to June 1989 and that the respondents themselves granted extension of time to complete the contract up to 31st December 1989, despite there being no request from the appellant. Full stop. We fail to understand as to how a person who abandoned the contract in May 1987 could be granted extension of time up to December 1989 on the very understanding of the respondents that the contract was up to June 1989. Full stop. In fact, the High Court recorded a finding in paragraph 9 of the impugned judgment that according to DWs 3, 4 and 5, the power to rescind under clause 3A of the tender was invoked and the security deposit forfeited, full stop.